If we don't compare, probably we do not progress also. So this comparison helps us progress, but as an intellectual, we must know the line of distinction. Where should comparison start? And number two, whether a comparison should be done or not. How to find apples should be compared with apples and orange should be compared with orange. And that we will try to know that how our Supreme Court has committed some of the blunders by comparing apple with oranges and the intelligentsia also. For this, I will try to discuss some of the cases that I have deeply dealt with. Now, when we talk about comparison, so a comparative study, we mean that, okay, we compare with America, with UK, with other jurisdictions. This is one meaning of comparison. Is there any other meaning of comparison? Or is it limited to just jurisdictions? You can say yes, only limited jurisdiction. There can also be an answer. That when we say comparative study, that means going through with different jurisdictions, that is geography only, geographic, limited to geography. No answer. If you don't answer, your silence. Socio-political, economical aspect. Can you little elaborate? Thank you very much. So if I'm comparing, maybe take example of federalism or take example of one law, any penal law. So does it mean that we have to see the cultural and social aspect of UK, USA, and in India? Do you mean like this? If it is so, then it is again jurisdiction specific. My point is, it's yes, cross-cultural. For example, that is got it, madam. Got it. Thank you. Please introduce yourself one by one, please. Yes. Yeah. Yeah. So again, come to again, madam. Then that becomes geography. The answer can be yes. It is limited to geography. Yes.
Comparison can be geographically, but sometimes comparison can be also historically, comparing the historical period.
Historical period there can be comparison. So pre 1950 and post 1950 can be one comparison. That is good. So this is another way that it needs not be geographical. This is one. Any other? Can also be compared. Yes. Yeah. So it is natural. The current days, if you remember, especially the students of criminal law would remember that these days we are comparing one criminal law with other criminal law. Are not we doing this these days very much? Any example? BNS with comparison that we are making, and we are telling how, what is good and what is bad. So, so the yes, what is same also yes. So the point is that the students should be communicated that when we talk about comparison, we do not talk about jurisdiction only. Jurisdiction certainly is one very important thing because About jurisdiction, probably we do not discuss too much. Things are not easily available also regarding other jurisdiction, so it becomes little attractive. Greater contribution can be made when you're making a comparison, but this is not limited to jurisdiction. As you likely said, that it can be history, it can be a period also, 10 years, 10 years, 10 years, and we do it. It can be between laws also. So a comparison between special criminal laws and general criminal laws. And the courts in many cases have made comparison, that what is the provision under CRPC and what is the provision under special law. Take example of bail cases. So how bail cases are dealt with in CRPC and how it is dealt with under special laws. For example, 438 of CRPC, anticipatory bail is available, but in certain cases, for example, take example SC/ST Act, anticipatory bail, the provision is expressly debarred. Expressly. So we make comparison. So students should be conveyed that, number one, when we talk about comparison, whenever I talk to the students in ILI कि कुछ comparative कल पढ़ के आइएगा, so they have done certainly good, but they only go to jurisdiction. This, as a teachers of law, we must convey that you find new ways of comparison. Don't just limit yourself to this. Why this is more important? For me, it is more important. Why? Because the cultural context, because the historical context, because the structural context, because the financial context is different in different jurisdiction in comparison to comparison being made in the same jurisdiction. So if you are making a comparison of special criminal law with general criminal law in India, and if you are making a comparison of special criminal law with special criminal law of USA, probably there would be various difficulties, because various contexts are different. So every comparison to me should contain both the things. A comparison made in India, and let them take any one example. Now, let us first focus on the jurisdiction. Comparative method. I need not to dilate on why this comparative method is good, because the healthy practices and unhealthy incidents of foreign countries, they always help us. If you go by the Constituent Assembly debates and the making of the Constitution, we will find frequent reference of comparative jurisdiction. We all know how B.N. Rao was asked to go to different jurisdiction in order to know the healthy practices of various countries. And then with the help of these all practices, the Constitution was made in. And sometime we, maybe out of ignorance, we always say that our Constitution is just a copy paste of the Constitution of various countries, which I personally consider a type of derogatory statement that intellectuals should not make, because they have not dealt with properly. It is very easy statement being made that the Constitution of India is a copy paste of that. So to begin with, we often know and we have read when we start our classes in LLB about federalism and what is the federal structure, and then we come to the conclusion that okay, our Constitution contains distribution of power, but the distribution of power has a different type of nature. Therefore, our Constitution should not be molded like USA Constitution, and cannot be, therefore it should not be said that our Constitution is not federal, as many people have said. So it is given different type of names, sometimes quasi-federal, sometimes unifederal, as in 1999 in my dissertation work, my supervisor has coined this term of unifederal, which finally got published in ILI also. So quasi-federal, unifederal, maybe some sui generis, these type of names are given, and that is the product of this comparison. When we discuss federalism, separate distribution of power, I find that there is one small thing that should also be compared in the classes. Immediately, maybe for 4 or 5 minutes. It gives great clarity. What is that comparison? The comparison between distribution of power and separation of power. And I have found that around 30 or 40% of class is probably confused. Whenever I asked, without having a type of leading question, that is there any difference? Then initial answer is not always very much positive. Means this is something at the level of LLM, 100% answer should be correct. But unfortunately, 100% answers are not correct. So we all are teachers, and therefore in the class, sometime when you teach federalism, some time should be given to make them understand that distribution of power is not separation of power. And so this is one point that I want to discuss. This comparison, this again is another comparative method. So separation of power can be found in both the entities, like in the states as well as center. But distribution of power is pan-India between two entities only. So distribution of power cannot be found in UK, but separation of power can be found. So these type of differences brings greater clarity. The second point, so far as jurisdiction is concerned, is regarding fundamental right. And the students of constitutional law, they know that our courts have used comparative jurisdiction in order to interpret various articles. Take example of Article 19. Article 19 is a more convenient example for me. Therefore, I am taking. One can take any example. If you have worked on Article 14, if you have worked in the area of 25, if you have worked in the area of 32, because through my book on law of sedition, I worked in the area of fundamental right at Article 19. I am in a better provision to discuss with you. Anyone who remembers that on Article 19, the Supreme Court has made a comparative study on Article 19. Some cases. I'm sure you know, all of you know the name of the cases. Even if you have not read the cases. Article 19, comparison has been made by the courts with India vis-a-vis other countries, especially USA. Teachers of constitutional law should take the lead. In context of Article 19, Hickling test. Okay, UK, okay, good. Good example. Any other? USA. No, no, no. I am asking. My question is that if we remember any case law where Indian court has compared Article 19 with USA Constitution. Putta Swami case is ठीक है, that reference is very good, but see, that reference is very good one by one. That reference is very good, but I would say that Putta Swami is not on Article 19. But Article 19. So the question is, the issue is on Article 19. Huh? Huh? Chilling effect doctrine, but in which case, if you remember? I'm talking that chilling effect certainly has been brought in through maybe USA, various Subramanian Swami, very good. Subramanian Swami, very good. That is defamation case. For that challenge to section 499 of IPC, defamation case, and I think very good comparison has been made in that by Deepak Mishra. That thank you for pointing out, because Deepak Mishra has not only compared uh, Article 19 with other with which amendment is there in USA? Anyone remembers? Which amendment? Free speech. Which amendment? First, second, third, fourth. Giving you four options. See, I told you this is a class where there is nothing like prestige issue. A class is a type of temple. When we go inside the temple, we keep our slippers and shoes outside. Similarly, when I entered the class, I have kept it outside. I am willing to commit all wrongs and willing to be improved. So is expected from everyone. That is the whole purpose of this FTP. So don't think if my answer is wrong. So क्या कहेंगे यहाँ के लोग? I'm not worried at all. You know, a good number of my videos, around 60-64 videos are on YouTube. आज मैं देख रहा था, सुन रहा था थोड़ा. दिल्ली यूनिवर्सिटी में जो कंपैरेटिव रिसर्च पे 2 साल पहले दिया था, मैंने पाया कि I have given too wrong information. That is in the public domain. So we need not worry. The Supreme Court commits mistakes and then changes it. That is how the curative petition came in picture. So first thing of improvement and development is let us be ready to commit mistakes among colleagues and in the class also, and let us try to improve itself. हाँ बताइए. Yes, fourth amendment or first amendment or there is not many place in this class for remaining silence. Please don't remember. Not a formality. I'm not here for formalities. First amendment. और कोई जो इन दोनों से अलग आंसर देना चाहते हो? फर्स्ट ऑफ ऑल, सो इट इज फर्स्ट अमेंडमेंट. इट इज द फर्स्ट अमेंडमेंट. फर्स्ट अमेंडमेंट कब हुआ था? किसी को ध्यान में है? 1791 फर्स्ट 10 अमेंडमेंट्स आए थे, जिसको हम बिल ऑफ राइट्स भी कहते हैं. फर्स्ट 10 अमेंडमेंट जिसमें 8 ही हैं जो एक्चुअली फंडामेंटल राइट से डील करते हैं. हम लोग 10 कह देते हैं, 8 ही एक्चुअली फंडामेंटल राइट से डील करते हैं. Now the constitution of the USA was ready in which year? Anyone remembers? 1776. 76. ठीक है, 76 is a benchmark. I understand. 1787. दो साल का अंतर बिल्कुल याद रखना बहुत आसान है. 1787, 1789, 1791. बहुत क्या क्या है? 1787 the constitution was ready. 1789 all signed. 1791 first 10 amendments, Bill of Rights came in. Why is this information important for us? Is 1787 when the constitution was ready, was there any fundamental right in the constitution of the USA? The answer is no. Had there been fundamental right, why would have they made the amendment in first 10 amendments? 1787 when the USA constitution was ready, it had no fundamental right, no free speech, no religious freedom, no right to equality, no right against exploitation, nothing against slavery. Anyone can guess why is it so? When we make a constitution, what for the constitution is made? If constitution is a normal document, why make a constitution? Make a simple law. Why we make a constitution? In order to protect the rights of citizens. This is one. And to give rules of governance for the country. Two. And there may be any other purposes. So rules of governance have been given in the USA Constitution, but no fundamental right. That too, in a country which was colonized by British. They did not incorporate fundamental right. This is something like 1950, our constitution is made and there is no part third. How will you react? You will say, what for the constitution is made? This answer to this question, if you are aware, we will very well know how the comparison between India and USA should be made. If the answer to this question is made, this will help us. Can anyone guess why in 1787 Jefferson was there in the committees? We all know the greatness of the people like Jefferson. Madison was there. John Day was there.
87 it was just written. Even rectification done after 2 years.
Yes, 89. That was.
25 is 89.
Yes, so that is I'm telling that 1787 when the constitution was ready. Written matlab? No, I'm not getting the point. My point is the constitution was ready by 1787. In the draft itself, there was nothing like fundamental right. When after 2 years it was signed, there was nothing like fundamental right. And then after 2 years, the first 10 amendments came. But the point is, why no fundamental right? In a country which was colonized, which knows the value of freedom, which knows the value of liberty, why there was no fundamental right? Can anyone guess? बताइए. Nothing making a wrong guess. You are not going from 12 लाख से 6 लाख पे आने वाले नहीं है यहाँ पे कोई नुकसान नहीं है. In the beginning, they do not want in the beginning. थोड़ा apprehension रहता है कोई शुरू होती है बात तो. चलिए got a point. Yes. Slavery backing कैसे? Slavery, yes, okay, 13th amendment. Yes. So one by one, but we have to connect the dots. मैं अभी ये क्लियर नहीं हो पा रहा हूँ कि उसके कारण फंडामेंटल राइट को लाने की जरूरत ज्यादा थी ना फिर तो. So, okay, so do you want to say that the framers of the constitution, who were the great people like Jefferson, Madison, and others, they did not want to give equal right to this? No, that is just, see, we cannot, nothing is, we can just guess, make an intelligent guess and go to the history. ठीक है, हाँ. ठीक है, okay. So that is what I am asking from you and you. You mean to say that the makers of the constitution did not wanted to give equal right to slaves and blacks? You want to say like this? They might not have ratified, you want to say. So that means they wanted to they wanted to appease white people. They were also dominant in all sectors, and therefore they thought that so once fundamental right is this is not the right time, let them ratify, then we'll do. Okay. So both answers.
Not like integration like India. Look at the formation of the USA. It's not like India that we got all the states and we integrate. There was a fear factor in the states, and that's why they collaborate and become USA. It's not कि वो अपने मन से जाके जुड़ रहे हैं.
That is okay, but how is
ratification is done?
No, but I will come to the question. How is it related to not having the fundamental right?
Maybe in the beginning because of the rectification, as they say. They have not done the rectification in the state in major participation.
They had to they had to take control of the areas they had in the possession, and they fought their independence over the Britishers. But what exactly was the intent was that there were also certain states like Louisiana and all those states which were still controlled by the French, and they had to expansion of the USA was the ultimate goal of the founding fathers. That is how they.
So, but my thing is that then it becomes, see, if slavery, if the slaves did not get equal right, but if your case, if your argument is supposed to be correct, then it becomes far more important to have a declaration of freedom from the colonial rule which is still existing like French you are suggesting. So the reason I think is almost same that you have pointed out, that even those who were ready to make the constitution, they initially were very happy that, like British, in Britain, if you go to the history, there were great differences between those among whites itself, those in the feudal and part of the feudal lord, and those who were not part of feudal lord, even if white. So they were very happy. Now we all will be equal. When we say we all, they always mean we whites will be equal. We whites will be equal. But when it was suggested to them that if you give liberty, freedom, and equality, do you know what will happen? That means the black and white will be equal, not just whites will be equal. You are not talking about poor white and rich white. You're not talking about white in the lords in the USA and not in the part of lord. The UK has made them equal. You don't think that will happen only. The blacks will be equal. They will sit together. They will dine together. The slaves and master will be equal. And therefore, if you read one of the idea, they said equality is a dangerous concept. And this was one such reason, besides many other reasons that you rightly pointed out, that they did not want this in the constitution as a part of fundamental right. They had this idea that it will roll back one by one. Yes, type of charity giving, not right giving. They did not want to present a rights model, type of charity model, not a right model कि मेरा right है ये. Equality is not a charity. So this is how the USA developed, but ultimately agrarian countries, USA is divided into industrial agrarian countries. Agrarian had various apprehensions. They had the apprehensions that because of dominance of whites, uh, because there is no fundamental right, our rights can be compromised. So ultimately, they were promised that within few years, within couple of days, we are bringing amendment, and then the amendment came in 1791. So right from the beginning, the framers of the Constitution,
That is the undertone of the framers of the American Constitution, believed in racial discrimination,
yes,
which is still persisting even today.
that is, it is difficult to say whether it is persisting or not now. But the first
Few years back also there was a lot of equal rights.
no, but madam, if you say that the framers of the constitution, so whether this type of thing is still persisting in the making of the constitution or not, that is very difficult to
What
say.
I'm saying is the mindset of the general American.
Well, well, that
Even constitution makers who are applauded for making the US Constitution, in their mindset there was some if and buts about
yes, not they had ifs and buts. And if you read the history of the constitution, if you go through the federalist papers, if you read all three documents, they said that we reached to the conclusion that equality is a dangerous idea because people were not ready to accept that, oh my god, this is something like हमारे घर में थोड़ा सा जाइए, काम वाली क्या साथ में बैठती है, मैं अपनी काम वाली को बोलता हूँ अच्छा चाय पी लो, नीचे बैठ जाती है, उसे बोलते हैं भाई यहाँ बैठ जाओ सामने. She is very uncomfortable. And the neighbor who came, she found it very offended. कि अरे आपने साथ में बिठा दिया उसे. Don't think this is Americans only. This is an idea that we need to struggle. But I'm not going in that. Yes.
in American society, it is not only about the black and white. The inequality is also in terms of man and woman.
That's another. Yeah.
Because right now, the Project 25, which is very controversial related to the Trump election, it is there are many points in that project paper that relates to the women equal rights.
So first point is that the framers of the constitution, unlike ours, they were not ready to accept the reality and take courageous decision. Don't think it was easy for us. In 1950, when the equal right to vote was given to everyone, Dr. Ambedkar faced this. When the people said, आप क्या जो पढ़े लिखे लोग नहीं उनको भी इक्वल राइट देना चाहते हैं? अरे इक्वल राइट तो वोट तो केवल पढ़े लिखे लोगों को देना चाहिए क्योंकि उनको पता है पॉलिटिकल जो राइट्स है क्या होते हैं और किस तरह के लोगों को चुनना है. डॉक्टर अंबेडकर क्लियरली डिनाइड दिस. नो, व्हाट इज दिस? ये गलती, because they knew that this mistake was made previously. We have made up our mind, an equal right were not given, as you rightly mentioned. In the USA, equal right to vote was not given to women. It took a lot of time. Equal right to study, equal right to participate in the universities, equal right to many other things were not given to female, because there was hierarchy of human body, hierarchy among humans. So whites were better than blacks. Among whites, white male were better than blacks. But what is the whole purpose of this discussion in the comparative study? That when we compare with USA, we should keep in mind the making of the constitution and how these type of provisions came in. So discrimination in the mind of making of the constitution was there, and 1791, when the fundamental rights were incorporated, how many restrictions were there in the USA constitution? Anyone can suggest me? Do you remember any restriction in the USA constitution? A right cannot be without restriction. We all know. Anyone remembers out of 10 fundamental right amendments, how many dealt with any restriction? Especially the students of constitutional law, if they expected, they would have gone. There was none. There was none. So at a time there you can see two type of extremes. While in 1787 and 1789 there was no fundamental right. In 1791 there was a complete U-turn. They have given fundamental right having no restriction. No restriction. Here comes the difference between Indian constitution so far as free speech is concerned with India. India contains under Article 19 how many restrictions? Anyone can suggest me? 6 or it is 8 restrictions. 8 restrictions. Not 1, not 2, not 3, not 4. 8 restrictions when you talk about Article 19. 8 restrictions on which the state is empowered to make laws. So that is why the USA model is suggested to be a near absolute model. Near absolute. Why near absolute? Because they do not say it is absolute. Because the USA Supreme Court has developed certain doctrines like clear and present danger test, imminent lawlessness test, or police power test. They have brought in, but in India, we need not to do it because the restrictions are already there. And in 2023, in Kaushal Kishore versus government of UP, the Supreme Court said the Supreme Court cannot impose new restriction. The restrictions are already given. Why is this important? Because in USA, the Supreme Court can impose new restriction because there is no restriction at all. So when a comparative study, so far as Article 19 is concerned, and that is good for other fundamental rights also. Because right to religion, there is no restriction. Many other rights, there are no restriction. So there are two things that we should take care of, especially the LLM students, PhD scholars, and when we write papers or discuss, that fundamental rights are provided in both the constitution, and that way our country and their country, the USA, is almost in the equal pedestal. Second is that they do not have express restriction, we do have express restriction. And third is that judiciary is empowered to place new restrictions. But in our country, judiciary cannot place new restrictions, and one of the authority is the new authority, latest authority, that is Kaushal Kishore versus state government of UP. Now, when we discuss Article 19, sometimes the judges forget this fact, and therefore they make very all celebratory remarks which is made in USA Constitution, thinking that the same can be imported in our country. It has not been done once, but many times. Not by one judge or two judges, but many judges. Of course, some of these judgments have been rectified later on, considering that the approach was completely wrong. I give you a small example of a new case from 23. Arup Bhuiya versus the state of Assam. Anyone remembers, because this case was controversial? I don't expect everybody knows the answer, but anyone who is deeply interested in the constitution, especially free speech and freedom of association, may have gone through what is this case, may not have read the whole case. Anyone? Arup Bhuiya? Arup Bhuiya case is on Tada. There are three cases: Arup Bhuiya versus state of Assam, Ranif versus state of Kerala, and there is one more case, Sandeep, the Samdas versus state of Assam. In these three cases, on different laws, there was same issue. The issue was that I am an individual, there is a terrorist organization, there is an unlawful organization. I have started going in the meeting of those organizations. I go there, I sit there, I do nothing, I come back. Next meeting, I go there, I sit there, I do nothing, I come back. Take modern examples. There is a WhatsApp group. WhatsApp group is made by an unlawful organization, Babbar Khalsa, Harkatul Ansar, or these type of group which are involved in unlawful activities. Someone who says that you are a student of constitutional law, you want to know what liberty means, so can you join this group? You have to do nothing. I have joined the group. That group contains various discussions: how to break India, how to attack Prime Minister, what is the meaning of liberty, how colonization is going on in free countries, how India has colonized Kashmir, how Punjab people are being targeted and discriminated, how Nagaland a lot of discrimination and injustice is going on, how the Naxal movement is justified, how the attacks are justified because of one reason or other reasons, how this right to self-determination under United Nations helps us. A lot of discussion. I am a member of that. The question is whether this membership, my membership, not the membership of other people who are participating in the discussion. Yes, good, we have to do something. You are doing nothing. 3 people were arrested on this ground. That Mr. A has gone to the meeting 3 times. He knew the organization was a terrorist organization. He knew the organization was a unlawful organization. Unlawful doesn't mean it has been declared unlawful under law. The counter argument was that I have not done anything. Of course, I knew that this organization is an unlawful organization. I know the organization is a terrorist organization. But what is the actus reus? And where is the mens rea? I am associating with the organization. Is it punishable? The government argued it is punishable. Why? Because the law said anyone who becomes member of a terrorist organization shall be punishable by this 2 year, 4 year life imprisonment. 3 तरह के punishment है UAPA में. This question went to the Supreme Court. In 2011, in Arup Bhuiya, Ranif and Das, in these cases, Justice Karju and Gyan Sudha Mishra, they have first declared that a conscious membership of an unlawful organization or a terrorist organization is protected under Article 19. Article 19 protects it. It is a part of fundamental right. Because to become a member of an organization, good or bad, is a part of fundamental right. The restriction comes in picture only when I do something, or if I intend to do something, even if I don't do something, I intend to do something. So that was a very liberal approach. This judgment was appreciated and applauded by ultra liberals in our country, appreciated right from Wire to Washington Post, that India has become such a liberal country, it has gone closer to USA. The government was disappointed. It was a matter of disappointment for many, including me. So they filed a review petition in 2015. Review petition was finally decided in 2023. Meanwhile, the case came to my notice. I also found very bad about this interpretation. I've gone through the judgment. See, we are not exposed to TADA, UAPA or many other laws. But are you exposed to Indian Penal Code? Everybody is exposed to. Do you remember that in Indian Penal Code there is a provision that deals with membership of unlawful assembly? Do you remember section 141? Right from LLB, you must have read it many times. Unlawful assembly. And there is a provision that says membership of unlawful assembly also 143. Maybe you have not noticed it. It does not say mere membership. It said whoever becomes member, knowing that this organization, unlawful organization, intentionally joins the organization, is punishable under law. So even if I am not aware of the provisions under TADA or POTA or maybe current UAPA, we are aware. So what is the intention of that? The only requirement is that I should be aware that the organization is a unlawful organization, because they come under section 141 of IPC. And I intentionally join. And that is punishable. So our jurisprudence, Indian jurisprudence, right from beginning 1860, has accepted that membership, conscious membership, is punishable. In the three judgment, there is no reference of this section. Okay, you can write a judgment, and Supreme Court has authority to deliberate, to evolve a new jurisprudence. There is no doubt. But then you have to discuss that why this 142, 143 provision should be discarded. Maybe you can say that the law was made in 1860. In 1950, we had fundamental right. So prior to Constitution, maybe 143 had to be interpreted in one way. After 1950, 143 has to be interpreted in different manner. You could have argued there is no reference, not a single line on that. What is there in the judgment? A reference by reference of the Supreme Court judgments of the USA. In the Supreme Court, a labor organization which was involved in violent activities, which believed in communist ideology, that the power is only found through gun. There was a person who belonged to that organization. He was removed from the service. He went to the Supreme Court. The Supreme Court said that कोई बात नहीं है, ये ऑर्गेनाइजेशन बिलीव करता है, ऑर्गेनाइजेशन लॉफुल है, लेकिन इसने काम क्या किया है? क्या आपको कोई ये है कि इसने कोई उस ऑर्गेनाइजेशन के साथ कोई ऐसा काम किया है, इसने वायलेंस को लेके कोई बात कही है? The answer is no. Then it is okay, fine. You can remain a member of an unlawful or terrorist organization. I'm talking about previous cases which were decided prior to 2000, where it was said कि नहीं कोई बात नहीं है, वो है तो कोई बात नहीं है, आप देखिए कहां वो कर रहा है. अगर वो अनलॉफुल काम करना शुरू करा या उसका इंटेंशन है, show me the intention. He is only there, but that our right, our law protects. Certainly their law protects. Why? There are no restriction. Clause 1 is very simple. It says that you have freedom, your right is protected, free speech is protected, and there is no restriction. And which entity will produce restriction? The court will produce. So court have produced the restriction and said it will be restricted only if there is a proof of intention. In our case, restriction is provided in the Constitution. Not one. 8 restrictions. Sovereignty and integrity, security of state, public order, incitement of offense. These are 4 relevant restrictions which can come in picture when you consciously join a terrorist organization. I'm not arguing morality, but morality can also be argued. We all know, हम कहते हैं अच्छी कंपनी में रहना चाहिए. If you are in a bad company, it directly deals with the morality. Morality is a restriction, but I'm not arguing morality. So with that, we wrote a piece. I wrote a piece that the judgment is completely wrong because of four various reasons. It was published in Cambridge. When the release function started, Upendra Bakshi was there. I'm happy to say and glad to share that 3-4 articles he has referred. One was mine. That these articles must be read. In 23, so I discussed this in my classes continuously. In 2023, the Supreme Court gave the judgment on the same line. On the same line. Of course, that article was not quoted. But it seems that somebody must have read it. So the whole point is that when you make a comparison, you should be aware about the philosophy of that constitution. The US philosophy says that restriction, there is no restriction. Restriction has to be imposed by the Supreme Court. And therefore, you have right. In India, the situation is different. But when we discuss Article 19, when we write something on Article 19, are we aware of these type of restrictions? Are we aware of these type of jurisprudence? Do we expose our students that when you rush to recite, America में ऐसा हुआ है, England में ऐसा हुआ है, do we convey that we should know the background, that who is empowered? And our Supreme Court is not empowered to do. It is the Parliament that can place restriction or remove restriction. Not only that, there are 8 restrictions. What is the word used? I'm sure someone must have noticed. It does not say restriction on sovereignty and integrity. It says, in the interest of sovereignty and integrity. In the interest of word is deliberately used to give it a wider connotation. Not just, you need not to show that it definitely challenges the sovereignty and integrity. Only if you can show in the interest of, it is sufficient. So this is one point that I wanted to highlight. There are many other points in this judgment that the Indian jurisprudence has never been taken care of. US jurisprudence have been blindly imported from USA to India. Blindly imported because going into the philosophy, what is permissible and what is not permissible. But the comparison cannot be selective by ignorance or by deliberation. I do not know whether Justice Karji or Sudhagan Sudhaji, they did it deliberately. I doubt they did it deliberately. It is all a matter of ignorance. What is the matter of ignorance? They did not go through the 2010 judgment of the USA. The judgment was given in 2011. In 2010, there was a judgment by the USA Supreme Court. On which issue? On the issue, the name of the case is Holder versus Humanitarian Law Project. Humanitarian Law Project is a type of an NGO. They wanted to train terrorist organization. They said we want to train the people of terrorist organization to know what is right to self-determination under UN documents. How to plead your case in different international forums. We want to let you know what are the arguments in your favor, and therefore we want to train, which we know in international domain is the right to advocacy of the terrorist organization like LTTE, like many other organizations. So then somebody suggested that if you want to train, so why don't you take the opinion of the Supreme Court? Because maybe it is not permissible. So somebody filed a petition in the Supreme Court that our organization, which is an NGO, it is an international organization. This international organization deals with liberty, that believes in right to self-determination. especially of those people who are fighting for their liberty against the state, and therefore we want to know, want to let them train and teach them and tutor them that in the international forum, how will they place their arguments in a non-violent fashion. We don't want to teach them in them violence. We are not supporting them in violence. We are indeed against it. We want to support them in their philanthropic activity. Like a terrorist organization is there. These days, terrorist organizations have two types of group. One deals with violence only, other is an intellectual group. The intellectual group deals with philosophical foundation of their terrorist activity and separatist activity. They will find argument. They will talk about justice. They will talk about liberty. They will talk about freedom. They will talk about the provisions in the constitution and UN documents. But they are well equipped, better than what we are equipped. Intellectual. So we want to associate with this intellectual organization. We are against violence. They have clearly mentioned. And then they said that there is a USA law which said that anyone who gives a material support to any terrorist organization shall be punishable. So, is it a material support or not? Please interpret the law. Please interpret the law. Because we are supporting in a non-violent activity, we are not with them. You kill people, we are not with you. You want to kill, we are not with you. We want to say, don't kill people. But we are training them. What the Supreme Court has decided. Before what the Supreme Court has decided, we should know how the Supreme Court had decided in 1919 free speech. In 1919, around 102, 3, 4 years back, SNAC and SNSCHK versus USA, the Supreme Court decided that the free speech is very extended. There must be a clear and present danger. A clear and present danger. And if there is no clear and present danger, you cannot restrict free speech. So if you know there is some danger, it has to be clear, it has to be present. That means a reasonable danger cannot be a restriction. It has to be clear and present. With the passage of time, in 1969, another case came in, that was Brandenburg. In Brandenburg case, there was a white supremacist group. They were against all type of facilities being given to blacks, like reservation, other facilities being given. So they thought that the rights of white people are being taken. So they invited people of all whites against the discrimination made against white, injustice being done to the white people, and they stick together, and there were various types of placards, and the placards used to say, "Nigger down, down, down." Nigger or the blacks, you will be placed in the place to death. And then there were various arguments and various speeches which said, if the government keeps on doing this type of facilities at the cost of white people, then there will be bloodshed. People will take arms in their hand and they will kill others, including the Negro. This was the type of speech going on. There were placards written that shows that they were deliberately made it. Then some people were arrested and then they were prosecuted. Matter went to the Supreme Court. Supreme Court said that whether any activity took place, like any violence took place, the answer was no, there was no violence. So the question was, then why did you arrest these people? What were they doing? No, sir, they were protesting against. So if they are protesting against the rule, if there is any law, like this, there is any law that deals with protest, if there is some harm, please book them under that, take compensation from them. If the road is blocked, then take compensation from them. But why prosecute the person under criminal law? They said they were talking against the Negro people, and then there are chances of violence. They said chances of violence are not a ground under a First Amendment. Was there a clear and present danger? And if so, where is the evidence? Whether they both parties up arms and going to fight? No, sir, there was no such case. Nothing doing. Proceeding quest. That was the level of free speech there. In our country, can you take the name of a person who is from SC/ST community publicly? अरे तुम तो इसी कास्ट के हो, तुमसे क्या होगा? It is offense under IPC as well as under SC/ST Act. You in USA can say like this. It may be a civil violation, not a criminal violation. This is the level of free speech. The Supreme Court judges, the intellectuals in our country, many of them do not know this difference. It is our responsibility to pass this information, this philosophical established information to the next generation who are doing their research work, that it is very good. You are taking information from USA, but please take note, this is the difference. So coming to the judgment, what the court has decided. The court that decided in 1919 clear and present danger test, the court that decided Brandenburg has taken a complete U-turn. They decided something which nobody thought of, that a liberal Supreme Court in USA can decide like this. The Supreme Court said that you are an NGO, you want to teach something non-violent, how to do advocacy for a separatist organization, it is not permissible under law. It amounts to material support, therefore it is punishable. And one of the reasoning given was that you do not know the fine line of difference between what is violent and what is non-violent in these cases. So the example that was argued in some comment was that suppose there is a terrorist organization or a unlawful organization and they have opened a school for their children, a school for the children of the terrorists and the separatists who were killed. I have opened a school and I have invited you. Will you come and teach the students in the school? Who are these students? Sir, these students are the children of terrorists who are fighting. Maybe Al Qaeda, maybe Harkatul Ansar, maybe BAT, the current terrorist organization, which is every 5 days that is killing one of our soldiers in Jammu and Kashmir. So their father is doing this, but the children has no fault. They want to go to school. Can you go and teach them? The US answers, no, you cannot. They say that in order to teach, why do you want to become a member of the organization? They are not stopping anyone. They are not stopping. They are telling that why do you want to become a member of that organization? This NGO has argued that we want to become member of their organization which is running their philanthropic department. I want to become member because they say that unless you become member, we are not allowing you in our camp. First, you have to become member. The court said, you help them if you want. No problem. Why do you want to become member of the organization? The court said it is not a part of free speech. The Supreme Court judgment did not mention this. Not a single line on that. So even if you rely on the Supreme Court judgments, we should know that there are new judgments which have changed the philosophy, which has changed the idea because of change in circumstances. Because US has also faced 9/11, they have changed their idea regarding free speech. And then we will know that there are various judgments which has changed, like Trump versus Hawaii case in 2018. That is also something which has curtailed the liberty and given the USA a speech. So the whole point is that when we make a comparative study is not something like looking at something openly. Comparative study means you go deeper and deeper, know the taste of the fruit, know to what extent this is helpful to my body, and whether it is equally helpful to others' body. Just because two things look round, apple does not become orange and orange does not become apple. So this is the first thing that a comparative study should be take care of, that not just a comparative study इस provision में ये है, इस provision में ये है, इस provision में ये है, which most of the research work is done. Most of the research, there is some criticism which has no strong basis, mostly like judgmental. I can tell you with strong conviction, I'm in the editorial board or maybe editor of two UGC recognized journal. Unfortunately, we have to, despite all many good things, good work done, means the collection of material shows that a good great work has been done, but then that is mere collection of materials. USA में ये है, UK में ये है, ये judgment आया है, ये judgment आया है. They have not gone in the judgment inside. They have not made what we often say critical study. So this is how we try to develop. पाठक साहब, मुझे आप बताइए कि टाइम कितना बचा है, तो उसी अनुसार मैं थोड़ा सा आगे बढ़ाने का ट्राई करूं. 5 मिनट और है हमारे पास, तो लेट मी सी 5 मिनट में मैं क्या कर सकता हूं.
Better to talk another topic. I just want to provide you some information to look upon the first discussion. Here, when we are talking about why fundamental rights are not there, after doing some preliminary research, I just found out that there is one state in US, Nebraska, is the center location of the US country. So Nebraska was having that unicameral structure, and that was not able to settle with the, because many other states at that point of time was unicameral was very much proposed, whereas UK based influence was bicameral. So when they want to come up with bicameral setup to establish, first 13 states were objected and several other also been supporting that way. So later to finalize, so bringing many of the 49 means the states able to settle and Nebraska left out like that. And finally, because of this difference only from 1781, the development of all this constitutional structurization, so was carried for a decade period, and 91 finally with this adjustment, even today Nebraska is means unilateral and rest 49 states are bilateral and bicameral. So by that way, this thing was delayed for establishing that fundamental rights to come into a conclusion of one settlement.
Thank you very much, sir, for this information. So the first point that comes to my mind, that why this difference is limited to fundamental right only. How was the federal structure then decided, how the governance of Supreme Court was decided, how the power of the executive was decided? If the bicameral and unicameral was the reason, how only fundamental rights remained curtailed and not others?
Yes, for that also, this is the reason why 87 and 89 was debated for 2 years. So making this settlement, so when they got majority and only one or two, making these kind of, in that case, this unicameral condition was a debate from 81 onwards. Because bicameral was started working from 1341. From England, bicameral started working in 1341, but Europe, many other states who are having difference of opinion,
That is
unicameral
no,
is good in governance
no,
and
but
bicameral is
God,
good in
God,
governance.
sir,
These are all. But that's why draft, see, intellectuals are working in intellectual side, making the line to take ahead how we can, because Nebraska, if it could have been on one corner, they might have removed from this union. Nebraska was on the heart of, like Bhopal के जैसे भी इसमें बीच में पड़ गई तो they were agreed to just accept and just move ahead respecting them. They said that adamant. Even today they are saying that we don't want. So in that reason, likewise, not only one difference like black and white, our people said that many other differences. These are also very major concern. Even today, women and men concept, even 20th century. So women was a property concept was being carried. But this difference to dilute and carry upon was required some kind of pacification. Like ignoring that is one way of tactfulness, because intelligent people will think that I can handle other way also. So in that regard here, the drafters also carried it ahead, saying that we will just work out with this in this condition. Okay, whether bicameral or
Sir, I got everything. My whole point is this is This shows that there was structural debate in the USA among various states, but I'm not still able to know and understand. And if anybody can make me understand, I will be grateful to him, her, that how come the whole constitution was ready, bicameral, unicameral, agrarian, this central, or on the border, how come fundamental right comes in picture? Means for fundamental right there was all these problems, and for other powers given to state, legislature, executive, judiciary, these problems did not come. So this is coming to my mind, but maybe you are correct. I will study further. But currently speaking, I respectfully not in agreement with this particular argument that this can be one such base. बट ठीक है, एक और कमेंट कोई आप बता दीजिए. आई थिंक द टाइम इज ओवर. Otherwise I wanted to discuss this another confusion regarding the law of sedition. So law of sedition was, fortunately, the name is removed from Bharati Nyaya Samhita, and section 152 of Bharati Nyaya Samhita now incorporates what is known as offense against sovereignty and integrity. But the spirit to some extent is same as the law of sedition. Now regarding the law of sedition, the current status even prior to 1st July 2024 was that there is a type of stay. There is a confusion. There is a stay on sedition law. There is no stay on sedition law. FIR can be registered, but there is a type of stay on sedition law for last maybe 1-2 years. The argument to remove sedition from comparative jurisdiction came from two places, mostly from UK and then from New Zealand and then from other places also, like Australia, that these countries have removed their sedition law and therefore India should also remove. And then we have taken up these lines and started maybe writing that okay, this is done, this is done, this is done, and many papers that some of them were published, many papers that came for us, maybe for Gilly, maybe for ILA Law Review, maybe for other journal. I found the same argument like a template that UK has removed, New Zealand has removed, and I also thought that it is removed. When we started working on this law and started going in that what happened to what was the history in sedition law, I found that the first proposal to remove sedition law came in 1977 in UK. 1977. 2009, the sedition law was removed. How many years? Around 30 years or more? 32 years UK took when the Law Commission recommended repeal of sedition law. And then I tried to know why the Law Commission has recommended, and let me tell you, I have read the Law Commission report, and our Supreme Court judges and our members of the Law Commission, they should read the reports, and we must know, we must learn many things from English. How to think differently. We are not doing it, dear friends. Do not just blame the British and the Americans that they have dominated the intellectual world. They have dominated because many of them think better than what we think, write better than what we write. The level of discussion and thought-provoking ideas that were there in UK report, I hardly find. I have read many reports of Law Commission. I am not able to find an unfortunate commentary on the intelligentsia in India. With all due regards to many good works which has done by Indian intelligence. Very compelling argument on democracy. That UK democracy is there, it was never threatened. UK democracy is only threatened by one thing. Can anyone guess what is that thing? Irish Republican Army. Irish Republican Army wanted a separate place and started their movement in 1929. 1934 they had made a law, suppressed them. And then the movement continued, violent movement continued. In 1977 the movement was going on. 1992 there was some compromise. But the UK said nothing doing, we are not going to remove it. The sedition law, we are not going to remove it. 1998, there was then compromise, further compromise. In 2000, they have brought a law, UK brought a law, Terrorism Act 2000. When you will see the provision in 2000, before 2001 attack, you will be surprised to know how harsh the provisions were. How harsh that you go against, do anything against integrity and security of UK, the police will knock your door. Burden of proof is on you. Of course, they are more responsible than our police and our prosecution, and to some extent our judiciary. 2000. 2004-5, Irish Republican Army came to the table and they said, first time, that they will not resort to any violence, nor they propagate, nor they justify violence. When they came to this, then the UK government started thinking that we should now remove sedition law. Not because Irish Republican Army is now very clear that we are not going to do this, but also because we have alternate provisions under which law? Terrorism Act 2006. Compare with India. 1971, a report of the Law Commission on Indian Penal Code says sedition has to be there. 1997, 257th report of the Law Commission, IPC, says sedition has to be there. 2017-18, a Law Commission has given some, maybe some, not report, but some papers published that gave an impression probably that they want to remove. But there's nothing conclusive, like UK. Which terrorist group is coming to the table and saying, I'm leaving violence? In Nagaland, they have done. They have been given their reward. Which terrorist group? They are telling, yeah, we will kill more people. We are proud of it. They kill those who contest elections. So, two things. And third, our laws are very good now. Strict, not as strict as the UK law is. 2019. How about if I say, आपने लिख दिया अगर how to make bomb और सर्च कर लिया, what will happen? In UK, the police can knock your door. You may do it for many purposes, maybe for research. The UK law 2019 was amended. See, the star of democracy. UK law 2019 was amended. Section 57-58 to incorporate. If you download a material which can be useful for separatist purpose, terrorist purpose, you will have to be accountable. Burden of proof is upon you that you are doing it for research purpose. You are doing it for journalistic purpose. We will only come and arrest you if you do not justify. So downloading is one. You think, okay, download में कुछ तो काम किया है. You have not downloaded. You have only served it. You are surfing. The provision is there. That police will come to your door and ask, why are you doing it? And if you are doing it for research or journalistic purpose, which is an exception, then show us that you are doing it for this purpose. Otherwise, it is your duty to it. So these were some of the reasons that in our book in 2018, we said that the UK and the New Zealand is a type of very, very bad example which is taken up by some of the intellectuals. What is the geography of UK? India is 13 times greater than UK. What is the population of UK? Uttar Pradesh. UK has around one. What is the population? Can anyone guess? 7 crore, 8 crore hardly. 7 crore. So if you add Bombay, Kolkata and Delhi, it becomes. Do not talk about. How many UK population can come in Uttar Pradesh? 3 times at least. When we make a comparison, let us make a comparison, not just thinking this provision is there, उन्होंने हटा दिया है, हमको हटाना. No. The correct way is, number one, to go to the history, see the structure, see their philosophy, see the geography, and see the population. Law and order has to deal with the population. So with that, I conclude this part of discussion. Thank you very much. I wanted to speak and I can speak for more than many hours. But thank you very much for a very, very insightful question, discussion. comments. I'm really very satisfied. Thank you. Still, I'm open to any question. Any